minor children. Appearances, please.
Brent Huckabee on behalf of Miss Bailey of the Movement.
And Ms. O'Brien.
Bridget O'Brien on behalf of Sean Holcomb, who is both the respondent and the counter petitioner in this case.
Hi, I know that both of you have motions before the court. Mr. Huckabee, what is your motion that you have for today?
Your Honor, I have a first amended motion for enforcement of possession for access, and Your Honor, I'd also make an oral motion to dismiss Ms. O'Brien's motion to modify. The order being requested to be modified was signed in August of 2020. However, the allegations she's using in that motion were prior to that date, thus they should be blocked by res judicata. And since it was not within a year of the order being signed, they have to prove that since the date of the order being signed, there's been a material and substantial change of circumstances that significantly impacts the mental and physical well-being. Seeing how their two affidavits were from incidences before that date, I believe they should be stricken from the record and her motion to be summarily dismissed.
Ms. O'Brien, as far as the allegation that the affidavits are regarding events prior to our last order.
Your Honor, we announced an oral agreement on May 14th of 2020, whereby we entered into an agreement with regards to what was inside of the order that was signed off in August. If you'll recall, I filed a motion for a new trial, and you told me the best recourse when we had a hearing was to go ahead and enter the orders as is, as was announced in May, and that if there was a need, that I needed to file a motion for to modify after that point in time. You, J.D. Smith was representing the petitioner or the movement in this case, and he wanted to go ahead and enter the orders because they were agreed, and he argued that they were essentially a mediated settlement agreement and had to be entered and then modified later.
I believe Mr. Huckabee, I had not remembered that, but I think that's true, is that there was an announcement at one point, motion for new trial. I'd forgotten that, but yes, I remember that, and that I felt like because it was an agreed order that we need to get that on file, and then we could deal with anything that had come up since then at a subsequent hearing. I believe that is the order that I made at that time. Now, I understand that you may want to take that up and have that reviewed by someone else, but I believe that is the way I thought was the best way to proceed. And so I'm not going to strike those. Now, let me ask this. Are the allegations that are, and Mr. Huckabee, I'm asking you, are the allegations in the affidavits since the announcement of the agreement in May?
It is my understanding that they are from early July, Your Honor.
Okay.
However, I would, just for to protect the record,
Sure.
yes, it's true, Ms. O'Brien has a motion for new trial, which is within the 75 days. I believe that if the court was going to take it up, she would have to, the court, based on the case law saying that from the date of the order, the changes have to be made, the court would have to open up the new court, but they still have the 75-day preliminary power on the motion for new trial. And if that's the case, then my client can bring in anything from the previous order of 4 years ago, which is a continuation which led us to this date where we are today.
You know, and Mr. Huckabee, I do not want to restrict you from making your record. If there's something else you feel like you need to make in your record, I'm certainly going to allow it to do so. But my ruling is going to be that at the announcement of that agreement in May, that is our time frame. That is when I orally pronounced an order approving the agreement, and we're going to go from that date. If that was the agreement, things that have happened since then, I'm going to allow. Things that happened before that agreement, I am not. That is kind of, and if you need to make more record, I'm certainly going to let you do that, because I understand you might want to get that reviewed, but that is my rule.
So can the court make a official finding on the record that he is denying the motion for new trial filed by Ms. O'Brien?
I am going to rule that on Ms. O'Brien's motion for new trial, that I rule that the appropriate way to proceed would be for me to sign off on the agreed order from May, and then address any subsequent issues after that in a motion to modify.
Okay. Thank you, Your Honor.
Anything else preliminarily, Mr. Huckabee?
No, Your Honor.
All right, now, one of the things I want to do is I want to, before we begin testimony, and I'll let you do an opening statement, but Mr. Huckabee, I want you to tell me specifically what you're asking the court to do today.
Your Honor, I'm asking that you find Mr. Holcomb in contempt for failure to follow that order from the agreement in May, signed in August, and that my client be allowed to have makeup visitation for the 45 or 50 days that my client has missed with the child since that date, and that the court sua sponte modify the order to ensure not only does my client get her visitation, but she gets counseling with the child in an effort to correct the damage that is caused to the relationship due to Mr. Holcomb's failure to follow the order that Ms. O'Brien's requesting to be modified.
Okay, and Ms. O'Brien, specifically, what are you asking for today?
Your Honor, I'm asking for the court to deny the motion for enforcement. We believe the evidence will show that the movement has not attempted to exercise any visitation since July 2nd. We've also got other evidence in regards to why the order should be modified. The child, Your Honor, as a preliminary matter, I do want to let you know that the child is present and is wanting to testify today. She's 16 and a half.
Your Honor,
when you say she's present, does that mean that she is listening?
Yes, Your Honor, and I wanted to bring that to your attention before we get started on anything else.
Okay, just a second. I do need to make, it reminds me I need to make this live. Okay, so if she is going to, Mr. Huckabee, whether or not I talk to her, I'll allow you to respond to that. But if she is going to be a witness in this hearing in any way, either privately with the court or whether one of you calls her to testify, she needs to be excluded from the hearing until she testifies. So where is the minor child?
She is with my client right now, Your Honor.
Okay,
And
I see. All right, this would be Haven, correct?
yes.
Haven, at this time, I'm going to place you under oath. You raise your right hand to be sworn. Okay. You solemnly swear the testimony you give in the cause before the court will be the truth, the whole truth, and nothing but the truth, so help you God. I can't hear you. All right. Well, at this time, Haven, you're going to need to be excluded from the courtroom. That means you cannot listen to the rest of the hearing until you testify. And that may be privately with me in some way, or it may be in open court. But at this time, you're going to need to leave. If we were in court, I'd say you need to leave the courtroom. Obviously, we're not in a courtroom, but you will need to leave the area where the Zoom hearing is going on. Does that make sense? Okay, thank you. All right, Ms. O'Brien, you may continue.
Your Honor, we are asking specifically for the court to temporarily modify the visitation. I think after the court hears the evidence, the court will determine that it's in the best interest of the child to modify the possession schedule And maybe, in my opinion, we'd ask that it be, through a counselor. If there is any visitation, it be done through a counselor.
So, Mr. Huckabee asked for counseling between the child and the mother, and that sounds to me like that's kind of at least to that limit. Are you in agreement with that?
Yes, Your Honor, we are.
Okay, so we are. We've got at least something that we can agree on. Is there needs to be counseling between Miss Bailey and Haven? All right. Now, how are you asking the order to be modified?
Your Honor, at this point in time, we think it would be in the best interest of Haven that the visitation be suspended and that the counseling sessions between the mom and Haven take place before there's any further visitation ordered.
All right, and now, Mr. Huckabee, if you would, what is the current order? To refresh my memory, I know I actually have it in front of me on my screen, but refresh the court on what the current order currently states.
It's a standard possession order, Your Honor.
With Mr. Holcomb having the right to designate primary residence,
That is correct, Your Honor.
and then Miss Bailey has standard possession.
That is correct.
Okay, all right. Ms. O'Brien, anything else preliminarily before we begin testimony?
No, Your Honor.
Mr. Huckabee, anything else preliminarily before we begin testimony?
No, Your Honor.
All right, Mr. Huckabee, again, y'all correct me, but I believe that you were the first to file in this case. Is that right?
That's correct, Your Honor. We filed our motion for enforcement, set it for a hearing on October 7th, I believe. It was moved to the date. We had it set up to be in-person hearing. And then Ms. O'Brien, I guess, contacted Tammy and said, we want it on Zoom, and somehow it ended up on Zoom, even though it was our hearing to begin with in person.
Okay. Now, my understanding of, let me just ask a couple more questions. Ms. O'Brien, this is from conversations with the court coordinator, who Mr. Huckabee, just for the record purposes, referred to Tammy, that is the court coordinator. Is that you're under quarantine at this time?
Yes, Your Honor, I was under quarantine at the time that we initially set the hearing. Moreover, one of my witnesses is a police officer, and he works out at the school, and he was only available to testify via Zoom. I explained that both of those circumstances to Mr. Huckabee, and I did not hear anything back from him. And I didn't purposely set the hearing. It wasn't initially set for an in-person hearing for today. I wanted to clarify that. When we called to get dates, we asked for a Zoom hearing. It was never set. We actually were the ones who initiated setting it for today and asked for a Zoom hearing. I just wanted to clarify that point.
Okay, and I think because we already had this one set for today, I gotta tell you, the weather is such that I am not driving to Carson today. I'm not. That's not happening. But Mr. Huckabee, are you ready to proceed today in a Zoom format? Zoom format.
Yes, Your Honor.
Okay. And I think that because you were first to file, I'm going to allow you to go first. Any objection to that, Ms. O'Brien?
No objection, Your Honor.
Now, one of the things that, just from listening to you, it appears, the court's on a motion to, let me ask you this, is a temporary hearing on a motion to modify?
That's correct, Your Honor.
All right, on a temporary hearing, I normally limit my witnesses to parties and one on a temporary hearing. But I will let y'all deal with that as we go. All right, Mr. Huckabee, who will be your first witness? I'm sorry. Do you have an opening to make? Do you wish to make an opening that we haven't addressed?
Yes, Your Honor.
Eric, you may.
My client is Miss Bailey. She's the mother of the child Haven and her older sister. For the past several years, she has been fighting for the opportunity to be a part of her children's life. last summer, Haven actually
Your
approached.
Honor, if I may, I would argue anything that is last summer, prior to the announcement of the orders in this case in May of this year should not be talked about or addressed. And I don't want to open the door to that. I would argue that that's res judicata.
Your Honor,
I'm going to, this is my ruling on that, is I'm not going to allow testimony about, things prior to, the May, announcement of the May order agreement. However, in order to give the court background, I am going to allow, if Mr. Huckabee or you, Ms. O'Brien, feel like it necessary to give a little background, to the situation, I'm going to allow that in opening. But I'm not going to allow testimony. But in order to me to have a picture, because I want to have a broader picture of where we are in general, just to have a general idea of the situation. However, Mr. Huckabee, I'm telling you, unless you can show me some reason why I should, I am not going to allow testimony of prior to the last announcement of the hearing, and Ms. O'Brien, by allowing Mr. Huckabee to give me background, he is not opening the door, and you are not allowing the door to be open for that kind of testimony. Does that make sense to both of them?
yes, Your Honor, and I'm not trying to, I'm not gonna have any testimony prior to, the May order. I'm just giving you a background.
All right, that's what I want. All right, you may proceed.
During last summer's visitation, the child expressed a desire to live with my client. Upon the child going back to the dad, within a few hours of the child being back to the dad, the child said, nope, I don't want to do that. I don't want to see my mom. I don't want to do anything. So they fought the case up through May, and in May they entered an agreement that my client would have the standard possession order. In June of that year, of 2020, the visitation went somewhat good. There were some text messages back and forth between the parties. I believe that Ms. O'Brien has entered some of them or submitted some of them for the court to view. However, there was not the full conversation. Come July 1st, the child is not brought to the meeting place. The child is subsequently brought on July 2nd. The child was at my client's house for maybe a couple of hours, and due to the child not liking the orders of my client about staying off her phone, an incident happened. Well, the child ends up gets a hold of her dad, and since that day, her dad has not brought the kid back because it was still her summer visitation, not brought the child to any of the visits in August, any of the visits in September, any of the visits in October, and now is saying, I want to take the kid permanently. Now, yes, Ms. O'Brien said that, oh, the child will want to do counseling. We know that counseling is going to be several months long. The kid's already 16 and a half. This is just a further example of Mr. Holcomb trying to alienate the child from her mom and allowing the child not to be subject to the order that Mr. Holcomb himself agreed to in May. And it is apparent that unless something is done and Mr. Holcomb is found in contempt, because according to the case law, Mr. Holcomb is required to bring the child to the meeting place at the start of every visitation. Ms. Bailey has been at the place in Borger for the visits every Friday of her visitation, and Mr. Holcomb has refused to show up. Thus, Mr. Holcomb is in contempt for the violation. And now he's trying to have the court modify it, so it's saying, oh, it's okay, you can alienate mom all you want, and I'm perfectly fine with it. And, Your Honor, we do not believe that's in the child's best interest, and Mr. Holcomb should be held responsible for not doing what he's supposed to do and follow the court order and ensure that the relationship between my client and the child is a strong one and a good one, and going forward, a productive one. Thank you, Aaron.
Ms. O'Brien, do you wish to give an opening now, or do you wish to reserve?
Your Honor, I'll go ahead and respond and let the court know that there is definitely more to it than just a disagreement that happened on July 2nd. On July 2nd, Haven was visiting her mom. She was there less than an hour. The stepfather proceeded to chase her around the kitchen, trying to take a phone out of her hand. She also was accosted by the mom, and her phone was taken by her stepfather, and her phone was destroyed. She was kicked down the stairs by her stepfather. She was pushed. She was so afraid that she fled the house, and she is scared to this day to return to her mom's care. Mom told the police that Haven was no longer welcomed in her home, and Dad, Sean Holcomb, has not heard from Jesse since July 2nd until the day after he was served with this case. When he was served with the motion for enforcement, suddenly he gets a text message from Jesse saying she wants to visit with Haven. From July 2nd up until October 9th, no text messages, no phone calls. The last communication that he had with her, she said she did not want to see Haven. Before that, there are also text messages in which Jessie said she wanted to relinquish and terminate her parental rights when it came to Haven. There's a lot more here than meets the eye, and my client would have met if she would have contacted her. He knows that he has to comply with the court order, that the last communication that he heard from her was that she wanted nothing to do with the child. So we're asking strongly that the court deny the motion for contempt. We're asking that the court modify temporarily to get the child into counseling with the mother and try and figure out if there is a way to rebuild that relationship.
Mr. Huckabee?